On its face, Governor Kathy Hochul's plan to address car insurance costs may seem like a no-brainer, going after fraud, incentivizing good driving, limiting legal awards for drivers largely responsible for crashes, and implementing stricter definitions of a quote-unquote serious injury for the purposes of lawsuits. But trial lawyers in New York argue the governor's focus is misplaced and doesn't do enough to address the role insurers play in driving up premiums. For more on what could shape up to be a contentious fight between the governor and the Democratic majorities in the legislature, we're joined on the Capitol Press Room by Andrew Finkelstein, president of the New York State Trial Lawyers Association. Thanks for joining us in the studio, Andrew.
Really appreciate the opportunity. Thanks for having me.
So I guess for starters, as a level-setting question, before we get into the root of New York's car insurance rates and the governor's response, do you agree that car insurance rates in New York are too expensive?
Well, I don't control car insurance rates, but it's a matter of affordability, and yeah, they're too expensive.
Okay, so let's get into then the governor's plan, because there are elements of it that seem kind of like window dressing when it comes to maybe the anti-fraud stuff, and it remains to be seen how meaningful that will be in terms of addressing fraud and lowering costs. But the areas of contention, let's get into them. And one of those areas has to do with the state's no-fault insurance requirements, which were established to avoid personal injury litigation and reduce costs to the system by trying to ensure prompt recovery of awards for injured parties. In practice, though, there is a critique that this coverage allows for non-economic compensation claims linked to a person's quote-unquote serious injury, and while elements of what constitutes a serious injury is very well defined in law as the type of quantifiable things that's not up for debate, there is a section of the serious injury statute that is ambiguous and also covers, say, a relatively short period of time, at least 90 days. So the governor wants to strike out that portion of the serious injury language. What's wrong with potentially removing that ambiguity, or at least tightening up the language in order to reduce the payouts for potential pain and suffering that might not necessarily be a serious injury in the eyes of most people?
Well, let me clarify a few things.
Sure.
Because I've listened to some of your old podcasts.
Thank you for listening.
And Josh Gold came on here and was totally wrong.
And for listeners, Josh Gold was representing Uber in that case, and they are looking for a decrease in their commercial insurance rates here in New York and have set their eyes largely on one of these areas.
Right. So there's he has a complete misunderstanding in the way you articulated that question. I want to ensure you don't have a misunderstanding.
I appreciate it.
No fault relates to payment of medical benefits to the doctors for medical care they provide to the individual and lost wages to the individual that they may have, along with a host of other components of what may be called economic loss.
Okay.
That's where no fault applies. And regardless of fault, you get those benefits. However, in order to recover anything over and above those benefits, two things must be true. One is fault. We must find the person who caused the crash at fault. So the no fault statement does not apply to the pain and suffering that one seeks. And the second element that must be true must be that the individual suffered a serious injury as defined by the statute. And it's already clearly defined. There are 9 sections that define it. I'm happy to go through all of them. I don't want to bore your listeners, but there are clearly 9 sections. The governor has selected one of those clearly defined sections and wants to eliminate those people's rights to recover.
So you say clearly defined, and the parts that seem clearly defined to me are where it talks about something like a break, something that you can
fracture.
see.
I'll run through them quickly for you.
Okay, sure.
Fracture, death, dismemberment, loss of a fetus, significant scarring, not just any scarring, significant scarring, unable to do your normal daily activities 90 out of the first 180 days. Why is that the one that's that is clearly defined in law? And the courts have clearly defined what is necessary. It requires medical proof together with objective evidence that you have an injury. What it does is it covers, for example, a traumatic brain injury. A traumatic brain injury is not clearly defined in any of those other sections, but people who suffer a traumatic brain injury and are unable to do their normal daily activities, that's the catch-all so that people who are seriously hurt can recover.
So why not just add traumatic brain injury and other examples of serious injuries to the statute as opposed to saying, nope, what we have right now is perfect? Because I'm not aware of the trial lawyers coming to the table with an alternative to just what the governor has proposed, which is striking out this paragraph that I think a lot of people would say is pretty ambiguous.
Well, it's not ambiguous in the court system. It's ambiguous to people who may not understand the law.
Well,
but
it's ambiguous in the sense that judges get to interpret this. They get to interpret, well, what constitutes this person's usual and customary daily activities, which for somebody might be their like to go skiing, and now they can't go skiing. For somebody else, it might just mean they like to do housework. So there is ambiguity that needs to be interpreted. But sticking with the idea, though, I want to stick with the idea of, would you be okay with opening up the serious injury statute to say, let's add traumatic brain injury, let's add something else, and we think that there is some wiggle room here, or do you think the status quo, the language that's in there, is perfect?
So I think the status quo is fine because you have a misunderstanding of that. Judges don't decide that. It's juries. Right? Judges, at first a judge makes a determination whether or not it qualifies to go to a jury. If people don't have the requisite evidence that they have a serious injury, then that case is dismissed. Then ultimately a jury of our peers, the civil justice system, which is the foundation of what New York State trial lawyers represents, access to the civil justice system, jurors are the ones who make these determinations, not judges. And it's people of our peers who have listened to all the evidence and say this person qualifies with a serious injury and they should recover. And I will also share with you, there are plenty of jurors who hear the evidence and say, no, they don't qualify. But who's it best in the hands of? The jury system or some other party? I firmly believe, and all of my members firmly believe, the jury system.
So you feel like our elected representatives aren't the ones who should be weighing in on this, the people we've delegated to make up these decisions. You feel like we should be leaning more towards the juries to decide what constitutes a serious injury.
Well, the legislators have already done it. They've set forth.
Oh, sure, but they're potentially going to revisit it.
Sure, and if they want further definitions of more injuries that automatically qualify, we're totally open to that.
As long as there still is that wiggle room for juries to decide those examples that might not fall into the statute very clearly.
That's what happens. It's a catch-all provision because it's just not realistic that every single injury will be clearly defined.
So another area the governor is looking to address is what a driver who is deemed, quote unquote, mostly at fault for a crash can collect in terms of those non-economic damages, thinking pain and suffering. I think intuitively most New Yorkers would think, well, why should someone who's causing a crash or is at least mostly culpable for a crash be entitled to anything from that less culpable party and their insurer? So are you on board with what the governor is looking to do here, or do you feel like the governor and their supporters, like the insurance industry, are misrepresenting this issue?
They're totally misrepresenting the issue.
I'm shocked to hear that.
And let me explain why.
Sure.
Here's the reason why they're misrepresenting it. All they're trying to do is limit what they have to pay out. So I'm going to give a very simple fact pattern. In New York, if you are responsible, you do not collect for that portion that you're responsible for. So I'll give you two different hypotheticals. If you are found to be 40% responsible for a crash, you're entitled to 60% of your damages.
Sure.
And the reverse is true. If you're found to be 60% responsible, you only recover 40%. Now, what the governor is proposing is the person who may be 60% responsible and is entitled to 40% of their damages, the insurance company gets the windfall of the benefit of now not paying any of it. And that's just not fair.
And after a quick break, we'll continue our conversation about car insurance costs and efforts to bring them down with Andrew Finkelstein, president of the New York State Trial Lawyers Association. When we return, we'll talk about the lack of criminal prosecutions of car insurance fraud and also consider whether New York State should begin offering its own car insurance products to compete with the private insurance market.
Support for the Capitol Press Room is provided by New York State United Teachers, a statewide union of nearly 700,000 professionals in education and healthcare.
This is WCNY's The Capitol Press Room, and we're continuing our conversation about efforts to bring car insurance costs down in New York. And our guest is Andrew Finkelstein, president of the New York State Trial Lawyers Association. Intuitively, though, I imagine you understand why people might be frustrated by the idea that someone who is a majority responsible is going to get anything, because it would seem like without their involvement or without whatever they did, this crash or accident, however you want to frame it, would never have happened.
Also with the other party, if it's 60-40, there's somebody who was 40% responsible.
Sure.
And they should pay for that portion of damages they're not responsible. And when I say they, let me make it crystal clear. It's the insurance companies we're talking about. So all that happens is the insurance companies are looking for a windfall to not have to pay out what they owe.
Although us as ratepayers theoretically would benefit by having fewer payouts, or do you think that their effort to reduce payouts doesn't necessarily impact what our premiums are?
So, Dave, I've listened to you several times on podcasts. I don't view you as somebody who believes in the tooth fairy. Do you believe in the tooth fairy? I mean,
I will say money kept showing up, so
yeah.
there's somebody there who's looking out for Dave Lombardo.
Yeah, I mean, Dave, you got to believe in the tooth fairy. If you think insurance companies, if they don't have to pay what they owe, now it's going to go back to their policyholders. It's just not in the world that I live in have I ever seen that happen. There are profit motive organizations that serve their shareholders. They take the excess profits and give dividends to their shareholders after they give monster bonuses to their CEOs. Their CEOs' salaries went up 27% last year. They're in tens of millions of dollars. Nothing goes back to the policyholder.
Well, sticking with that idea of cynicism and people's motives,
it's not cynicism; it's fact. If you can show me,
Sure.
If you can show me any example where an insurance company voluntarily,
yeah. But I'm just saying, I want to pivot to the idea that as trial lawyers, isn't there a vested interest in bringing as many cases as possible and squeezing the system for as much money out of it as possible where you can?
That is, I'm happy to address that. When, as trial lawyers, we work on a contingency,
Sure.
which means we only are compensated if we're successful. I don't know any lawyers who bring cases they believe are losers.
Right, but
they believe that their client does not meet the serious injury threshold.
But they see the landscape as one in which they can potentially make money. And I guess what the governor is trying to do is lower the threshold for those instances where someone might be successful, and therefore there's less opportunity for attorneys to profit with lawsuits.
She does it under the guise of affordability.
Sure.
And none of that will have any impact on affordability. All it does is increase the profits of insurance companies. So really what she's saying is, let me take away consumers' individual rights, the individuals who need it the most. Let me take those rights away, their opportunity to recover, and for the benefit of only one party, the insurance company. So it has nothing to do with affordability. And it's a fallacy when it's put forth that it is.
And you brought up the idea that insurers on their own, even if they see their costs drop, are going to offer some sort of discounted premiums to drivers. And to that end, the Trial Lawyers Association has pointed out that the state has regularly approved the rates that ultimately trickle down to car insurance purchasers in New York, the drivers. How would you like to see the state use its regulatory authority over car insurance companies and the rates they look to charge? Because I think, speaking as just myself, I was not even cognizant of the role that state regulators, that the Department of Financial Services played in approving car insurance. I always think about them in the health insurance space, but how much authority, from your perspective, do they have to basically set car insurance rates?
Well, there's a distinction between authority and exercising that authority.
Sure.
They have the authority, but they've seen it, and when I say they, the Department of Financial Services, part of the executive branch, Governor Hochul's own branch, has allowed insurance premiums to go up 24% over the last 4 years, 13% just last year, and they just rubber stamp it. And now, why do I say they rubber stamp it? Because they've never said no to the insurance company, because it's an awful powerful lobby for the governor.
Not like those trial lawyers who come here hat in hand with no influence in Albany.
Well, it's not that we don't have influence in Albany, but we represent the people.
Okay.
And we help the people recover what they're entitled to, and we protect individuals' rights. We represent that. The reason why legislators are aligned with trial lawyers is because we represent the same constituency, the people of New York State, as opposed to the big corporate interests. And going back to Department of Financial Services, DFS, they have the authority to require insurance companies to produce their claims data, and they never have. And they just come in and they claim that they have to increase these premiums, and they're allowed to increase it automatically 5% per year, which they do without any restrictions or oversight. And that was a self-created rule by DFS. They can easily say no premium increases at all, but they don't do that. And they do not hold the insurance companies to task. I have testified at hearings where I have heard DFS say, we don't know what the claim data is. We don't know how much fraud there is. They have never reported to us how much fraud, but they tell us there's fraud, so we believe them. And then I've been at the same panel where I've heard insurance companies say, we do not keep data with respect to fraud. But they run around with hair on fire saying fraud, fraud, fraud. Nobody suggests that some fraud doesn't exist, and make it crystal clear. Trial lawyers are totally opposed to fraud. It should be out of the system. But to suggest it overwhelms the system to justify these increases, it is not supported by any data, by any facts, and all it is a straw man, frankly, for them to give an excuse, because insurance companies' foundational business model is to deny, delay, and defend, not just claims, but also why they're increasing their premiums. They deny it's because they want more profits. They delay providing the additional information necessary, and then all they do is defend by putting out a little shiny object saying it's the trial lawyers, it's fraud, without any support. It is a total fraud that they're putting forth.
So sticking with the Department of Financial Services, if we do give them the benefit of the doubt, and just stick with me on this, and we say, okay, they're approving these rates because this is what the insurers say they need to make the math work in New York. And there have been reports that come out and say that the car insurance market in New York is generally not that profitable part of the business for these insurers, especially compared to other states. Is there any concern that you have about potentially limiting the number of players that operate in New York, or do you feel like that is a scare tactic from the insurers, this idea that they will get up and abandon the millions of potential policies that they can write here in New York? Because that would potentially lower competition and increase cost even more.
I'm not sure what your question. Am I concerned about that? I think it's a total. I think it's a total ruse.
Okay.
Frankly, because I watch television. If I'm watching television, all I see is a car insurance ad or a drug company ad, right? And both of those companies or industries are claiming poverty. Yet, if you look in the stock market, they're going all the way up because they have record profits. In 2025, all insurers had record profits. Look at Travelers, look at Chubb, look at State Farm, look at Allstate, look at Geico.
But is it possible that they're not making those profits based on the New York car insurance market, that they're doing that elsewhere, that the New York car insurance market is maybe a loss leader for them, for example?
It's the exact opposite.
Okay.
They're taking the profits from New York and using it in other areas where they are less profitable, where the regulators don't allow increases in their premiums automatically. Here, they just jack up their premiums. And by the way, and this is all supported. The Center for Justice and Democracy just came out with a report this past Friday. I encourage all your listeners to look at it, Center for Justice and Democracy, where they detailed the 10 insurers, and they all have record profits, and they all gave their CEOs monster raises in the tune of $134 million in the aggregate. So the suggestion that they're losing money here is just not supported by any actual evidence.
Sticking with the idea of fraud, and evidence, we hear from the Department of Financial Services that there have been 1,700 or so stage crashes in New York, with nearly 40,000 incidents of suspected motor vehicle insurance fraud that year. Given those numbers, I'm kind of surprised that we don't also hear about 1,700 prosecutions of staged crashes. So does it seem to you like we have enough tools to go after this fraud criminally, or do we need to increase the teeth of the criminal statute or the resources that prosecutors and insurance companies have to root out fraud?
Well, the Attorney General is committed, and it falls under the guise of the Attorney General to prosecute these cases, and I know she's fully intent, and we're fully...
The AG's office brings criminal cases in this case? I was thinking of them as a civil arm.
The AG has criminal prosecution powers as relates to auto fraud, but also the local prosecutor as well, and we support every prosecutor and the AG's office to prosecute any claim of auto fraud or staged accidents. We encourage them to do so. We are totally opposed to fraud, but maybe when you hear these alleged claims of staged accidents and frauds, maybe they're not actually true. I'm not suggesting none of them are, not at all, but when it requires evidence and proof in a court and it's brought to a judge, maybe it's just an inflated excuse by insurance companies.
What do you think listeners should make of the experience in Florida, where they took some action to regulate the litigation side of this conversation, and they point to a drop in car insurance rates for the state's, I think, top 5 auto insurers? Is that not a roadmap for New York to follow?
I don't believe taking away individual rights is a solution to an affordability when insurance companies are making excessive profits. And that's really what you're talking about. The scenario we talked about is when people have a meritorious claim, this government and frankly, the governor wants to exclude people who have meritorious claims from getting what they're entitled to and allowing insurance companies to profit from it.
Well, finally, there are about 2 months between now and when the final budget is due. And in my 15 years kicking around the Capitol, this was the first time I can remember there being a spotlight on this and a dialogue on this. So are you optimistic about the idea that there can be any sort of positive, holistic changes to the state law and the efforts to address fraud that result in car insurance rates going down? Or do you feel like we're headed on a trajectory that precludes us from maintaining civil rights, as you put it, and not just handing more money to car insurance companies?
This is where I am optimistic.
Okay.
I'm optimistic that finally New York may enact a law that allows and puts the power with the consumer and not with the insurance company by passing bad faith law. Bad faith law says this: insurance companies who choose to deny, delay, and defend meritorious claims, valid claims, there have to be consequences, and they will have consequences. Right now in New York, there's no consequences for an insurance company who there's a valid claim, they should be paying the claim, and they just deny it, or they require a consumer to go defend what the insurance company defends it, and they delay paying what they should be paying. Now, in other states where there is good bad faith law, which holds the insurance company's feet to the fire to pay when they should pay, those cases in those other states, they move very quickly, and it completely reduces the litigation expenses of insurance companies, and that's what brings premiums down. They're looking at it from a totally wrong angle.
Well, given your view of insurers and what motivates them, which I don't think is a viewpoint that is out of the norm at all, why not just have a state-run car insurance option to compete with these private companies, because the state wouldn't have the same motives? Is that something that we should be entertaining at all as a way to shake up the car insurance landscape?
I think that's a perfect solution. I think that's a perfect solution. Have a state-run option because what happens is the good drivers and I heard yourself on a previous podcast.
I have a pretty clean record,
You have
yes.
a clean record, no speeding, no citations, and your premiums go up. That should never happen. First of all, insurance companies should be required to justify why your premiums go up when you're a good driver. And then what's left are the, I'll just define them as substandard drivers who may have had some prior events. That's where a state pool would work perfectly. And then that took the burden off the insurance companies. That would drive premiums all the way down. That's a great solution. We would be totally for that.
Well, we've been speaking with Andrew Finkelstein. He's the president of the New York State Trial Lawyers Association. Andrew, thank you so much for joining us in the studio and for being a listener to the show. I appreciate it.
Yeah, it's my pleasure. I'm happy to be here anytime.
Support for the Capitol Press Room comes from O'Donnell and Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com.